He repeatedly placed food, seed, and water bowls on the exterior of the property to feed the squirrels. He admits to that. The conduct attracted squirrels, which are a rodent, which are a pest. It created unsanitary conditions.
Enjoy the video. Hit the like button.
708, Ms. Winkles.
And Your Honor,
There we go.
tell me when
Go
you're
ahead. I was trying to find you on my screen here. So
okay. I know that the other side is going to ask for this be set for trial, but this is not an appropriate one to be set for trial because all the facts are agreed. We agree that there was a lease. We agree on the lease. We agree that there have been 4 different 10-day notices. We agree that Mr. Manning has been feeding the squirrels. He fully admitted it in his declaration. Every fact in this case is totally agreed on. What isn't agreed on is the law and whether feeding squirrels when you've been asked to stop, if it meets the statutory definition and the contractual definition of what is a nuisance. And so this is the court is kind of tasked with a very narrow thing here under RCW 59-18-380, and that is just whether there's a genuine fact. There's not. So then we move on to the law. And again, the facts are not disputed. He signed a written lease for a 12-month term beginning November 1st, 2025. The lease has nuisance provisions under section 14Q and 14H. Those material terms were specifically initialed by Mr. Manning. Beginning no later than September 25, he repeatedly placed food, seed, and water bowls on the exterior of the property to feed the squirrels. He admits to that. The conduct attracted squirrels, which are a rodent, which are a pest. It created unsanitary conditions. It interfered with the neighbor's use. You can see that because there's neighbor complaints. You can see the photographs taken. Again, these are facts. Plaintiff.
Counsel, let me stop you just a minute. He admitted feeding squirrels, but not the other issues.
Okay, and
then there's a legal question as to whether feeding squirrels is a nuisance.
That's it. So the question is feeding squirrels a nuisance? And there are 2 independent statutory grounds here. The first is under RCW 59-12-030 subsection 4. When the person is guilty of unlawful detainer when they fail to perform a covenant of the lease and remain in possession more than 10 days after the notice to comply. He was given 4 of these notices, December 16th, January 26th, February 9th, and February 27th. Each notice described the conduct and asked him to stop doing it. The 4th notice was specific. He never complied with any of those. He breached a material term of the lease. And if you look at the lease, Your Honor, on
where am I looking at on the lease specifically?
The lease is attached to the complaint.
I've got that, but where in the lease?
Subsection 14 Q and H.
What page?
Q I wish the lease does have a page. Page 5 of the lease itself.
Five, section what?
So section H, if you look at noise nuisance, the last sentence of that, tenant shall not create or permit any other nuisance on the property.
Mm-hmm.
So that is a kind of a catch-all provision. The neighbors have complained. Obviously, you have those complaints before you. And if you turn the next page to 2 more pages, my apologies, to page 7, which is Q, nuisance, tenant agrees to not permit a nuisance or common waste. So the question is one of law, of what Your Honor thinks is a nuisance or a common waste. And so here we have the tenant allowing a squirrel, not just allowing, but encouraging squirrels to come onto the property. You can see where the food is located in the pictures. He states that he's put it right outside the door. He's had squirrels in his unit. He's admitted to all of this. Now, he says squirrels are harmless. He simply enjoys feeding them. That's not a defense. The fact is that it's still wildlife, number one. It's the same thing as encouraging deer to come right into your yard. It's the same thing as putting out rat food. So squirrels are a rodent. They're part of the rodent family. It is a rat with a fluffy tail. They cause just as much damage to property. You'll see the declaration of my client who states that they've already paid for squirrel infestation at another location. He says that he's not going to stop. You'll see all the photos after each one. He's been given notice. He's been asked to stop. This is a simple thing for him to stop feeding the squirrels. There's no reason for him to continually bring this pest in. Squirrels have been identified in other cases as a pest or a rodent. Granted, it is not an unlawful detainer action, but it's nevertheless they have been considered to be a pest or a vermin. The case, let's see.
Well, counsel, I don't have the case in front of me, and I don't know if it's been cited, so I probably gonna need some briefing on the issue.
And it doesn't really matter. It's common sense that you're asking wildlife to come to an apartment. He's been asked to stop. He's feeding wildlife at the apartment. That wildlife is part of the rodent family. If this was a rat and he were feeding rats or mice, getting them to come into the apartment, this would not even be a question. This would not be a question if we use the word rat or mouse. But it's only a question because we have essentially a rat or mouse with a fluffy tail that everybody assumes is really cute. They're still a rodent. They're part of the rodent family. They're an infestation. They carry disease just like rats, just like mice. It causes damage just like rats, just like mice. They gnaw. They have the same teeth. Essentially, it is a fuzzy rat. And he's been asked to stop multiple times. They've given him every opportunity. The question of law is before Your Honor. There is no question of fact here. It's whether or not that is a nuisance.
I would just like to dispute one thing. I do not believe my client ever admitted to having squirrels inside his apartment. I think that he said that he would feed them outside the squirrel. They're saying that he just broke a generalized lease provision for waste and nuisance, Your Honor. Waste and nuisance is usually done under 3-day. It's significantly more significant, and it usually says that there's some sort of lasting damage or like some sort of illegal activity. I think this might be a little bit more cut and dry for you if there was a specific lease provision that he was violating that said you cannot feed the squirrels, you cannot do that. There is no lease provision that says that, so he was doing that. But even if there was, I think you then need to look at the materiality of the lease concern and think, is this a provision of the lease that is strong enough to consider, breaking off the contract, as is the what is the 10-day standard, Your Honor? I would just like to note a couple different things. There was no allegations in this case of any sort of damage to the property. There's been no proof of any damage to the property. There's been no allegations that there's just all saying that this could happen, this could happen. So again, I think this really needs to be dismissed because there's no proof of any damage. We can't figure out materiality if we don't have any damage here. Because theoretically, my client, if it was a 10-day, he could comply, pay to make it better, do all these things. But there's no damage, so he can't comply. Therefore, the 10-day is just not correct, Your Honor. So granted, if we bracket that off, I think we need to have a trial on the materiality of if this is a material enough breach to consider, reneging on the entire contract, Your Honor. Again, we don't have any damage proven here. My client is just feeding them outside. He lives right across the street from the park where the squirrels are anyways. He's testifying that all the squirrel feed that he leaves out is gone within a matter of, hours usually because the squirrels eat it all. He's not feeding rats, which are different than squirrels. So, I think at minimum, this case needs to be set to trial to figure out the materiality. But I think this really needs to be dismissed because ultimately there is no damage here, Your Honor. They're not alleging any damage. They're not proving any damage. You can't call this a nuisance if there's no proof of any nuisance that occurred. Again, if they had proof that they brought rodents on that caused disease, we're in a completely different situation here. But there's no proof here, so I just believe that it's not material. Or if they could say there was some damage to the property, therefore, that is material. Again, my client could then have a chance to comply or fix the breach with money. But right now, I'm just not clear what the breach is.
Your Honor, if I might.
Sure.
A 10-day comply or vacate notice doesn't need damage. The reason that we didn't use a 3-day waste or nuisance notice is because this level of nuisance, number one, can be remedied by not feeding the squirrels. Squirrels will go away if there's no food present. You bring the squirrels and they expect the food, they will eventually go away. So this is something that Mr. Manning can easily remedy. They don't want him out. They want him to stop feeding the squirrels. That's why they gave him 4 separate 10-day or vacate notices. The fact is there is a danger. The moment you bring rats, squirrels, or other rodents into an area, you're creating an unsafe and unhygienic environment for the other people that live there. This is not a single family house. This is an apartment complex where everybody else has to live. They have to walk through the same entryway that all these squirrels are going to. Their kids have to walk through. There's going to be squirrel droppings. There's going to be feces and urine of these squirrels. That's what happens with wild animals. That's why they're so dangerous to have in living areas where they're communal areas. The moment you bring rodents into that area, you are creating an unsafe and unhygienic environment for the people that live there. That is why it's a nuisance. That is why we call it common waste. Is there damage yet to the property itself, to the buildings? No. There is a significant risk of a health and safety hazard to these people when you bring these squirrels in. There's also the risk to damage, which is why we did the 10-day comply or vacate. Now, how can he fix this? We're talking about damage. We're not talking about damage. How can he comply or vacate with the lease? He can stop feeding the squirrels. This is not a question for trial. This is absolutely a question of law. It's up to your honor to decide whether or not bringing squirrels in and feeding them, because we have no disagreement on that, and whether or not he brought them into his apartment. I will strike anything on that I've stated, and we'll go with that he didn't, that he put it outside the unit in the common area, and we can leave it at that. There's no question of fact. There's nothing for the trier to determine whether it's true or false. It is only for your honor to decide whether bringing squirrels in by feeding them repeatedly, even after you were asked to stop, whether that is a nuisance under the statutory rules, and whether it is a nuisance and a common waste under the lease. And that's it. Thank you, Your Honor.
Well, it probably needs to have, there's some disagreement on what exactly is being done. There's a lot of pictures of stuff which appear to be different parts of parks and sidewalks and steps and different things. I don't know.
Agree with
counsel, let me finish. Okay. I don't know what those are. I just have exhibits of pictures. And so I can either set it for trial. I'm not inclined to dismiss because there's at least a question of whether this is a nuisance. I will do that on the condition that Mr. Manning, while we're awaiting a hearing on this, does not feed any squirrels. Should he do so between now and when this is heard by the court, that would be grounds for an immediate writ. So I'm not making a decision that it's a nuisance, but while it's pending, no more squirrel feeding, and then we'll sort that out at trial.
And I've not gone to a trial over this issue. Do we need to set this on the universal trial setting docket?
Probably.
Okay.
So Mr. Kiernan, he'll let your client know he's not to feed
I
the
will let
squirrels
my
until
client
this gets
know.
sorted.
I'm not going to sit here and tell you that I might not bring a motion for reasons that he might want to continue to do that. We might cross that bridge when we get there, because I know that it is very important to my client. I understand that you're making a ruling, but I might make a motion that might explain why you might want to do something different. Or I just don't want to pair myself off from that. But if that does happen, that'll be through motion, Your Honor.
Be happy to look at a motion, but
yeah, I don't know what the motion would even be, quite frankly, Your Honor. But
let me finish. Unless I rule differently, no squirrel feeding, or he's going to be out.
Your current ruling is very clear, Your Honor.
Very good.
And do you
want to be on next Wednesday, 20th?
Yes, Your Honor. I think we want to get this resolved as soon as possible.
I agree. 20th at 9 o'clock.
Do you want me to draft that order, Your Honor?
Sure. Yeah, that would be great.
Okay, will do. All right. Thank you, Your Honor.
You're welcome.